The time has arrived. Will the clerk call the roll?
Kurtz.
Here.
Petrie.
Here.
Schrader.
Here.
Esri.
Here.
Bergson.
Here.
Harper.
Here.
Langenheim.
Here.
Quorum is present.
We have a quorum. With the permission of the committee, I would like to move agenda item 8D to just before agenda item 8A. Are there any objections? All right, consider it done. Also,
Move to approve the minutes.
okay, we got a second to that motion?
Second.
All in favor, say aye.
Aye.
Okay. Now, a motion to approve the agenda.
So moved. Second.
All in favor, say aye.
Aye.
All opposed, say nay. Nay. The motion carried. Yes, I do. I'm not looking forward to this at all. Let's see here, what do we got here? All right, we have a very large number of requests for public participation. Therefore, we will invoke the 1 hour rule. You will have 5 minutes apiece, and at the end of an hour, we're going to cut it off. All right. Now, we have only one request on this particular item, so Mr. Marcus L. Harris.
Thank you.
Is somebody timing this? Okay.
Hi, my name is Marcus Harris. I just thought since the public participation was open, I'm the gentleman who's requesting the zoning change for 1414 Triumph Drive to change it from an industrial 1 to a B4 to open an indoor gun range and a shop and a training facility. If you have any specific questions, when we get to that, I'd be happy to answer any questions. We went through the Zoning Board of Appeals. I just wanted to introduce myself and let you know I was here. And I'll be happy to answer anything at that time. So hopefully that's brief enough.
All right, thank you very much. Okay. Let's move on to the rezoning. Mr. Alan Singleton.
Good evening. Thank you for a few minutes to address this organization. We've had a long and extended hearing before the Zoning Board of Appeals on the rezoning and establishment of a special use permit that would allow the Jones family to use their acreage a couple of miles north of the county line along Route 130 as a restricted landing area. Dr. Jones has a helicopter and a private airplane, and he has used those flying machines to assist law enforcement. We have a letter from the Douglas County Sheriff, the Champaign County Sheriff, and an emergency management person that are included in your packet. I apologize for additional paper, but the case got so big over a 2-year period that I felt that just putting the key documents in front of you might be helpful so you didn't have to dig through everything. The Zoning Board of Appeals did vote to deny the special use permit, so you might ask, why am I here? Because the special use permit and the change in zoning sort of go hand in hand. And the answer to that is, I think if we were to actually get approval of the rezoning, it would at least get us a step closer to being able to address some of the neighbors' concerns and establish a special use permit and a restricted landing area on the property. Just to highlight, under tab 1 is the proposed what was proposed in the special use permit. The landing area is basically already constructed because initially he thought everything was going to fall under an ag exemption to zoning, and he would not have to obtain zoning approval. Turns out that the county did not take that position, and so we had to go through the Zoning Board of Appeals process. Over the course of time, we did move the proposed restricted landing area further to the south to get it a little bit further away from the closest neighbor. And again, all of that grass runway is constructed with the exception that the hangar has not been constructed. So that's sort of tab 1. Tab 2 is the letters of support from the Champaign County Sheriff. Having a helicopter in an emergency situation is clearly an asset to public safety. If you have a child who's lost in cold weather and you need to locate them, the helicopter can assist with that. It can also, right now he's got his helicopter stored roughly 30 minutes away down in Douglas County, and so that 30 minutes can mean the difference between life and death if it's 15 below zero in Champaign County and the wind's blowing. So letters of support under tab 2, tab 3. We're requesting a rezoning from CR to Ag 1. The special use permit would not be permissible in CR, although Piatt County has sort of a similar zoning category that would allow a special use permit in sort of their analogous zoning to CR. But we're in Champaign County and it's not permitted in CR, so we need to rezone to Ag 1. But I will point out that he's planted over 1,009 trees on his property. And is very much a conservationist. Additionally, one of the proposed special conditions of the special use permit was that he would establish a 1-acre forested area, and for every tree that was identified in the hangar area that was of sufficient size, I believe it was 9 inches or greater, he was going to plant 2 red oak trees, northern red oaks, to replace that. And so very much conservation minded, and we're mindful of the rezoning from CR to Ag 1. There's a couple of maps under item 4 and 5 that illustrate that, in fact, Route 130 is closer to the proposed runway than closer to the nearest neighbor than the proposed runway would be. And there are 1.2 million vehicle passes on Route 130 according to IDOT, 1.2 million. And this compares to the proposed limitation in the special use permit of 126 passes. So 126 compared to 1.2 million. I just illustrate that or give you that data to give you perspective about the intensity of the proposed use. This is not a public airport. It would be very much a restricted landing area and very limited in its use. So tab 6 actually summarizes that data. I tried to graph it, and the graphing software wouldn't register the 126 on the graph. The next item is item tab 7, and there's been testimony that the Fisher family, for example, does dog training lessons on their property. There's testimony by nearest neighbor Larry Hall about frequent shooting of guns in the area. Which is all fine and dandy. It's the country. You ought to be able to do what you want to do. You ought to be able to train dogs. You ought to be able to shoot a gun if you want to, as long as you don't hurt anybody. But you'll see that the noise levels of the aircraft fits very much into the middle of the noise levels that.
Mr. Singleton?
Yes.
You've come to the end of your rope.
Okay. Thank you.
Sorry. All right. Wayne Ward.
I'm Wayne Ward, a registered professional engineer. I was hired by Dr. Jones to prepare a plan for a proposed restricted landing area that met all federal, state, and county regulations. Now, regulations are not the same for each one of those agencies, so had to use at least a minimum requirements for each so that each one of them met. I've measured and calculated the existing land and trees to make sure that it fit properly between the roadway of Route 130 and the trees at the west end. trees still continue to be a problem or a concern at the west end, but according to my measurements and calculations, the proposed restricted landing area plan meets all federal, state, and county regulations, including the trees at the west end. Another issue with the trees is the area where they're planning to put a hangar. I've looked closely at the area that's been designated as the site for the hangar. If all of the brush and small trees were removed from the area, it would involve the removal of about 3/10 of an acre of brush and small trees. Talking about trees basically 4 to 6 inches in diameter. There are a few, very few, that are as big as 10 inches, but that's the largest. There's no older trees there. The largest tree is actually a cluster of 3 trees, which are the type of locust, which has a 2 and 3 inch thorns. There are no large mature trees on the site. I've taken pictures from all angles around the site to indicate that no large trees do exist, and I think you have a copy of that information. As I stated earlier, I know of no issues in the proposed plan that do not conform to the regulations of the federal government, the state government, and the county zoning requirements. Thank you.
All right.
Are there questions that you have, or is that?
No.
All right.
Mr. Larry Hall.
Larry Hall, 177 County Road 1600, adjacent to the proposed RLA Villa Grove address. Just to mention a couple of things. One, there was a comment made just minutes ago regarding the number of planes, indicating that the petitioner had a plane and a helicopter. And as was disclosed during the hearings that we had over a 2-year period of time, there were actually 3 other planes owned by the petitioner who stated he invested in planes, and his father, who is part of it, also plans to use the runway, also has a plane. So there would be more than initially sounded. Using the runway for the emergency, it's been done in the past apparently, and been done without any problem. Half hour is a stretch. There's not very many minutes, a few minutes between where the petitioner lives and where his plane's currently housed. Again, dwelling on the RLA, which is relevant to the rezoning, only because if one didn't exist, the other wouldn't exist. The petitioner works in Villa Grove, so depending on whether he was at work or somewhere away from home, which place would actually be the closest. Also, the runway is partially in a flood zone, which during periods of wetness, a grass runway could not be used anyway. So it would not be available possibly when mostly needed, versus being in a airport down Tuscola, I believe where the plane is now, which has a hard surface runway. So I just wanted to make clarification on those 2 points. Thank you.
All right. Gene Fisher? Whoever lives at 1956 County Road, 1600 F. Okay, thank you.
Yes. My name's Jean Fisher, and I live at 195 County Road, 1600 East. The testimony that both the public mentionings of Mr. Alan Singleton and Wayne Ward were part of nothing new evidence that was discussed in a 2-year period by the zoning board. The zoning board overwhelmingly denied both the rezoning and the special use permit. And the reason why they did that is they felt the conservation district was more important to uphold based upon the impact that would occur with airplanes and helicopters landing. There are large trees. Mr. Wayne Ward discussed the trees. He didn't discuss that the trees could continue to grow up to 100 feet. There are native tree species there that would encumber safe operation of takeoff and landings there. So there's less than, this board I'm sure knows, there is less than 1% of forested area in Champaign County. And this would impact, not just from a hangar aspect, but also the conservation area, which provides much to the natural habitat, the corridor for the Embera River there, the streams that flow, the watershed, prevention of soil erosion with all of those trees are there. So we feel that the zoning board more than overwhelmingly reviewed the evidence that was submitted over 2 years, and that's why they made the decision in a 5-to-1 vote. And I would just like to say that we are very fortunate to have such beautiful habitat that we currently have right now, and we would like that to remain as such. And that's all I have to say. Thank you.
All right. Okay, well, now I'll shift gears. Christine Maine.
Good evening, I'm Chris Main. I live at 1219 West Charles Street in Champaign. I'd like to speak tonight about our children's birthright. And right off the bat, I realize that when you start talking about, what are we leaving the next generation, it's almost become a cliche. It's sort of lost its power to impact us, It doesn't penetrate like it used to. It's as if we can't find the words anymore that can describe the wrongness of stealing from our children's future. For example, I think that it's our children's birthright to experience a great summer day on a clean, healthy river. Paddle the canoe around a bit, maybe swim if they're lucky enough to have that quality of water. I think it's their birthright to be able to cast a rod into a nice, cool pond and, try their luck with fishing. And I also think it's every little kid's birthright to catch a frog along a healthy stream and go scare his sister with it. And who are we to sell that birthright to an industry that's going to poison, deplete, and misuse tomorrow's water supply? I'm not an ethicist, but I don't think we've got the right to do that. One of the strongest statements I ever heard about nature was this: you can never fall in love with nature if you don't get to know her first. Are we teaching our children to know and love nature if their only experience of a river is on a game station or an Xbox or something like that? If the rivers are too shallow due to industrial depletion or too polluted to swim in, what kind of legacy is that, and what are we teaching them? If we raise children without nature, they'll never know the power that it has to inspire us, to teach us, and to even renew our souls. And worse, they will never teach their children about the natural world. And, that scares me. It really does. I don't like to think about that scenario. If selling water to Sunrise Coal is that important, if that money means that much to us, then I seriously wonder if we've lost our moral compass. And keep in mind, there's this one thing about stealing. The first time it's hard, the second time it's easier, and then after that you just keep taking. The next thing you know, the aquifer is dry, the river is just a gravel bed, so I think we can do better than that. I don't think we're a desperate community yet. We still have choices, and maybe we can even choose to hold back from this, this relatively short-term gain that might cause a lot of pain in the future. And I just hope that we'll make up our minds to put nature and our kids ahead of money and industry. And I thank you for giving me this chance to share my opinions tonight.
Robert F. Ilias.
I'm Bob Ilias. I live at 810 South Elm, Champaign. I want to talk about the proposed minimum flow request from the Hallador coal mine. The sanitary district, the UCSD, is the main source of water to the Salt Fork during severe droughts. The negative effect of drought on fish populations is increased by stream channelization, which is common in this county, and the UCSD contribution is critical. Some people have objected that the UCSD contribution is not natural, but they disregard the effect of its stream channelization, which is also not natural, and some extra effort is needed to do something about the effects. Before the enforcement of the Clean Water Act in 1972, the sanitary district discharges were seriously toxic to fish, but now they are actually beneficial, especially during drought, and fish populations are gradually recovering statewide on account of the Clean Water Act enforcement. In the drought of 2012, water levels in the Middle Fork were generally too low for boating, but not in the Salt Fork. The difference is that the Salt Fork is fed by UCSD, whereas the Middle Fork has very little contribution from sanitary districts, and so was a lot lower. Although the Salt Fork was adequate for boating, the levels at Oakwood were low enough that there was concern about the city water supply. Any reduction of UCSD discharge would place both uses of the Salt Fork at risk, and possibly the sport fishery as well. If it is decided to guarantee the approximately 500,000 gallons a day for the proposed Hallador Bulldog coal mine, plans should be made to divert at least 1 million gallons into the Salt Fork. The request is a bit odd. It talks about what, as I understand it, it talks about what we are to guarantee as a minimum, but what really counts for them is the minimum at their end. If we're going to give them their 500,000 gallons, we're going to have to put about 1 million gallons in at our end, because during serious drought, the evaporation between here and there is going to greatly reduce the amount of water that arrives. So 1 million gallons a day minimum, and it may be quite a bit more because there's some indication that the coal mine is going to want more than they're currently requesting. Also, if we do this, the price of the delivered water should be tied to the market price of water. We're talking about a relatively long-term arrangement, and the price of water is going to go up a lot over that period, so I think we'd be cheating the county if we didn't tie the contribution, the amount of water we deliver to the actual price of water in the future. I don't favor this diversion of water because it would be more cost-effective in the long run to remove some of the stream channelization, which is why we need the extra flow, and to use the discharge for irrigation, as Bruce Hannon suggested last night. Both would have favorable impacts on the aquifer, but if we do go ahead and agree to deliver what the coal mine is asking, we should make very sure that the sanitary district is fairly compensated. Thank you.
Mary Kay Solecki.
Hi, I'm Mary Kay Selecki. I live at 1 North Street in Sydney, and I work for the Illinois Nature Preserves Commission. I'm the commission's field representative for East Central Illinois. So I'm here to express the Nature Preserve Commission's concern about the resolution regarding the water withdrawal. The Illinois Nature Preserves Commission is concerned about potential impacts to the Salt Fork of the Vermilion River that may result from the expressed need for sizable quantities of raw water for a proposed coal mine southeast of Homer. The Salt Fork is home to a wide variety of native animals, including several state-threatened or endangered mussels and fish. These animals need clean and ample water in the stream to thrive. The Salt Fork of the Vermilion River is recognized as a high-quality stream, both in Vermilion County and the eastern part of Champaign County, by the Illinois Natural Areas Inventory, which is maintained by the Illinois Department of Natural Resources. There are 2 registered land and water reserves that occur along the Salt Fork northeast of Homer. Land and water reserves are protected habitats that are voluntarily protected by the landowners under the Illinois Natural Areas Preservation Act. The Illinois Nature Preserves Commission is statutorily obligated to protect natural areas such as the Salt Fork under the Illinois Natural Areas Preservation Act. Specifically, the alteration of natural water levels within dedicated nature preserves and registered land and water reserves is prohibited under Illinois' administrative codes. And other negative impacts to these protected habitats and the species they support is also prohibited by Illinois law. The Salt Fork of the Vermilion River has many existing uses that rely on clean and abundant water, including support of rare, threatened, and endangered species of mussels and fish, downstream water withdrawals for the drinking water supply for the village of Oakwood, and recreation uses including canoeing, kayaking, and fishing. The Champaign County Board, I hope, will be mindful of these existing water uses and work to ensure that they are not compromised. Indeed, the County Board has placed an emphasis on the protection of the natural resources and the environment of the county as expressed in the Champaign County Comprehensive Land Use Plan. The Illinois Nature Preserves Commission supports the resolution you are considering tonight, authorizing opposition to water withdrawal from the Salt Fork of the Vermilion River for coal mine use, and encourages county board members to vote yes on the resolution opposing water withdrawal from the Salt Fork for this purpose. Thank you.
Peter Kuchenka.
Okay, thank you. My name is Peter Kuchenka. My wife Betsy and I live on 2737 County Road 1250 North, just 2 miles north of the Homer Village boundaries. I sincerely want to thank the chair for bringing Addendum 8F, the proposed resolution opposing water withdrawal, before this committee. This is the first time, to my knowledge, in a year and a half that residents of the unincorporated areas of Champaign County who don't live in the village of Homer had a chance to present their case in front of their elected officials and constituencies. I cannot begin to express the level of frustration that myself, my family, and our neighbors have had over the year and a half with approaching the Vermilion County Board, with presenting the village board, the Homer Board of Trustees, with 250 plus signatures, with speaking up at trustee meetings, with putting up yard signs over and over, opposing and registering opposition to support for the coal mine, and being ignored, being labeled extremist, being labeled tree huggers, and worse. This is democratic process at its worst, when decisions that materially and negatively affect us in our community are made without representation of those who will be affected. You will hear much testimony tonight about concerns about the environment, the quality of life, etc. But let me add a perspective that is perhaps less often heard, and that's the economic impact on our community. I'm a university professor. I teach in workforce development. I'm also director of graduate programs for my college. And I'm often involved in faculty hires, bringing new researchers, professionals to our community. As you will have heard, the Chancellor announced last week the hire of up to 500 new faculty members over the next 5 years. Now, not all of these will be net hires. Some will replace retirees. But even if the net new hire number is in the neighborhood of 150, which is what the university announces, the net impact in terms of addition to payroll is in the neighborhood of conservatively $15 million per year. This is substantial. We traditionally face a lot of competition for the best and the brightest researchers and faculty members. We recruit nationwide, but a majority of new and young promising scholars come from other Big Ten universities and consider Illinois. They consider Illinois because of the reputation of our research university, but also because of the quality of life that our community has to offer. We compete with other small college towns like Bloomington, Indiana, West Lafayette, and University Park in Pennsylvania. And it is the natural beauty, the opportunity for recreation, the fact that we maintain an intact natural habitat that makes it possible to raise young families to have a high quality of life with the rivers, with the natural areas, with Homer Lake Park, with Champaign County Park, that attracts and helps us retain the best and the brightest. If we become known as a coal town, if the message goes out that this community is in bed with King Coal and materially invites and supports coal, with all the risks that coal mining involves, we lose a key competitive advantage that our university has. This is serious. Recreation and the intact natural habitat are not nice-to-haves. They're essentials for the type of employees and researchers that we try to recruit at the university. The village of Homer made two mistakes. The first one was to view the sale of water to the coal mine as a local issue, rather than an issue that affects the entire watershed, the entire community, and the system as a whole. Second, the village made the mistake of representing the sale of water as a zero-sum game. Either we gain economic benefits from the sale or nothing will happen. This is the wrong approach, and I urge you to support the proposed resolution in light of the opportunity for alternative models of economic development. We can build a community that is vibrant and has increased demand and revenue without supporting and inviting coal. Coal is dirty, coal mining is inherently risky, and even the best-run organizations cannot guarantee
Mr. Pachinko,
the
I'm
absence
sorry.
of industrial accidents.
You've reached your time limit.
Thank you very much.
Keith Roll.
My name is Keith Roll. I live at 527 State Route 49, south of Homer, 5 miles. My family and I live and farm in the southeast corner of Champaign County, and I want to thank the Environmental Land and Use Committee for allowing me to speak tonight. I have numerous concerns about the coal mine as being proposed along a 9-mile stretch of the Champaign-Vermilion County line between Homer and Allerton. The surface facility would be 1 mile into Vermilion County and be about 2.5 miles from my house. Sunrise Coal has not only leased the coal rights in Vermilion County, it has also leased acreage in Champaign County also. My concerns: contaminated wells. According to the permit number 429 submitted to the state of Illinois, the slurry pits will be constructed of 4 feet of compacted clay. These pits will contain mercury, arsenic, and other harmful metals. Part 4, page 20 of the proposal states this will help prevent the pollution of the surface and groundwater. Notice, it does not say will prevent. No water. There will be underground blasting. There will be water being pumped from the mine, from keeping it from filling up. How will this affect my well? Will it be drained? No one knows how my little sand and gravel well attaches to other areas underground and the potential for leaching out of water and in of chemicals. My family and others have great fears. Drainage. We know how important drainage is to our farm ground. In the proposal, Sunrise states that it will be diverting field tiles and drainage. Some of that drainage would include fields drained in Champaign County. What impact will that have? What will they do during heavy rain? Shut off the tile and back it up, or run excess into the olive branch, which leads into the Salt Fork? Coal dust. As we know, the wind blows and that dust will carry for miles. It will not stay in Vermilion County. What impact will coal dust have on our crops? Will it stunt the growth and our yields? Future value of farmland in the area could be affected. The potential for subsidence in Vermilion could affect some of the drainage from Champaign County farms. Increased truck traffic on secondary Champaign County roads. All of this and more will negatively impact the quality of life for people living in Champaign County. I want to urge you to approve the resolution tonight. Thank you.
Susan Forsyth.
Good evening. My name's Susan Forsyth, and I live at 208 West 4th Street in Homer, and I'm here tonight to talk about the resolution. I'm one of the new trustee-elects of the Homer Village Board, and I want to talk about the lengthy process that Homer went through to decline the sale of untreated water or from sewer effluents or any other source to Sunrise Coal. Part of the reason that Homer went in this direction was, in fact, to protect the Salt Fork and potential withdrawals from it. Taking up to 1 million gallons per day at peak capacity from the Salt Fork may not seem like much. However, in times of drought, it is indeed a lot and would likely affect the habitat of creatures that call the Salt Fork home. Some of those creatures include federally protected mussels, as you've heard, and the darter fish that the mussel relies on to reproduce. Even recently, actually just the other day, there were reports out of St. Joe that a mature bald eagle has been sighted along the Salt Fork, which I thought was pretty neat. And the same can be said downstream in the Middle Fork area. The thing is, to me, Homer set a great example for Champaign County by making the decision to not sell water that was driven in part by the desire to protect the Salt Fork at a local level. And you as county board members have the opportunity to dovetail Homer's decision and follow their example. This is especially important because this may be the only chance that you have to make your voice heard concerning this matter, as only a small portion of leased land is in Champaign County, the rest being in Vermilion County. As we all know, water is quickly becoming a commodity, evidenced by the potential sale of effluents for profit. So the question becomes, what happens when the time comes that the county needs the water in some capacity and it's contractually obligated to not one, but 2 water-intensive industries? What happens then? So my concern is this. The Salt Fork is a county treasure that people from not only Champaign County use, but surrounding counties as well. It's a huge draw for fishing, canoeing, kayaking, all sorts of recreation. People are passionate about this river because it's not like we live on the banks of an ocean, or we don't live on the Great Lakes, we don't live on the banks of the Mississippi. So it's not like we have an abundance of river recreation to be had. And I really feel like community values should trump the dirty consequences of both Sunrise Coal and Cronus Fertilizer Company, which I know we aren't talking about. But I do ask you to remember one thing, that people downstream of the Salt Fork use it for their drinking water supply. And is it really fair to expect another community in another county to have to upgrade their water treatment facilities so that the UCSD can sell effluents and concentrate the pollution even further? I would think logic should dictate the answer is no. Thanks for your time.
All right. Tom Smith.
My name's Tom Smith. I live at 2797 County Road 1200 North, just northeast of Homer and along the Salt Fork. I'm a former chairperson of the ZBA for this county, and I was a committee member for the Land Resource Management Plan that the county board eventually passed. I would like to encourage this committee to recommend to the county board to pass the resolution opposing withdrawal of water from the Salt Fork River for coal mine use. I'm here to speak for the river and its riparian corridor, since it cannot speak for itself. Withdrawing amounts needed for coal mine use during low flow will reduce the flow sufficiently to negatively impact the flora and fauna that depend on this river for life. I would also like to remind the committee of the county's comprehensive land management plan, one part of which commits the county to protecting the environment. Thank you for your time.
Okay, Tracy Barkley.
Good evening. I do want to make note that we have a map that Deb Busey helped us to put on the screen, and so for reference points for where some of the water community supply locations are. The green outline is the shadow area. I don't know if you can see, oh, well, I can see it. It was there. And we have copies, actually, that I can distribute. So the green outline is the shadow area, which is where the coal will be extracted out from underneath. The red area is the surface area, and those are in Vermilion County. But I did want to show that the wells shown near Ogden and Homer are community water supplies that will be used for the coal mine, and I also wanted to show the proximity for the salt fork. So when you get to the discussion of the resolution further down the agenda, I wanted to have those for your reference. My name is Tracy Barkley. I am a resident of Urbana. I live at 609 West Nevada. I went to school here. I met my husband here, who is he's a native of Urbana. We left for 3 years and came back, and we intend to raise our family here. Care very much about this community and its natural resources and the people that are here. I also come from a farming background, so I do recognize the important agricultural value of this county. I also work as a water resource scientist with the Prairie Rivers Network. Prairie Rivers Network is a nonprofit organization that strives to protect clean water and healthy rivers with and on behalf of Illinois citizens. I'm here to ask for your support of the proposed resolution to protect the Salt Fork River from withdrawals from mining operations in Vermilion County. You've heard from many Champaign County residents why this is a Champaign County issue, including threats to the agricultural economy, clean and abundant water, and our existing quality of life. We are here tonight to ask you, our elected representatives, to use the hard-earned Land Resource Management Plan and its guiding principles as you consider challenges to our land and water resources now and into the future. I have spent a fair amount of time with the plan, and I understand that it took quite a long time to work through. There's a lot of great intent and information in there, and I just wanted to, knowing how hard of a process that is to put together a comprehensive plan like that, I wanted to read the purpose statement tonight and read it slowly, because I think the words that many of you chose as part of this document are very important and serve as a guiding principle for you into the future. The purpose statement reads, "It is the purpose of this plan to encourage municipalities in the county to protect the land, air, water, natural resources, and environment of the county, and to encourage the use of such resources in a manner which is socially and economically desirable." I feel like two of the goals to achieve this purpose that are directly relevant to proposed withdrawals from the Salt Fork include the agricultural goal and the natural resources goal. And I just wanted to draw your attention to these goals. The agricultural goal reads that Champaign County will protect the long-term viability of agriculture in Champaign County and its land resource base. The relevant objectives associated with this goal include: 1, requiring that development will not interfere with agricultural operations; 2, seeking means to encourage and protect productive farmland within the county; and 3, seeking to preserve the landscape character of the agricultural and rural areas of the county. For the natural resources goal, which reads, Champaign County will strive to conserve and enhance the county's landscape and natural resources and ensure their sustainable use. There are several relative objectives, and I'll be brief, but one is adequate, safe supplies of groundwater, conserving soil resources, maintaining and improving surface water quality, encouraging maintenance and enhancement of aquatic riparian habitats, encourage resource management, which avoids loss or degradations of areas that provide habitat for native and game species, protecting investments in rural parkland and natural area preserves, and essentially the last one is protecting air quality. And I think if we look at what is proposed with Bulldog Mine, there are several threats to what the county board has set out as worthy of protection within the county. Development of the Bulldog Mine threatens farmland due to potential subsidence impacts, including damage to drainage tiles, change in drainage patterns, loss of topsoil, change in yield, difficulty in operations. And this is, I understand that the majority of what's leased right now is in Vermilion County, that are several hundred acres right now that have been leased in Champaign County, and we've heard from residents that there are additional signings happening in Champaign County. To Development of Bulldog Mine threatens a water supply due to direct withdrawal of both groundwater and surface water, discharge of polluted runoff and wastewater, potential contamination of the groundwater supply, and changes in drainage patterns. We feel air quality is threatened due to increased coal dust, land disturbance, and traffic, and that the quality of life is may be affected due to increased traffic, noise, damaged infrastructure such as roadways, coal dust, water pollution, and water supply loss. So thank you very much for your consideration.
Okay. That runs through our, anybody else want to talk? Okay.
I'm David Bodner. I live at 2504 East Perkins Road in Urbana, unincorporated Urbana. And I don't attend many of these meetings, but I have lived a great deal of my life along the bank of the saline. Some call it a drainage ditch, and some call it a creek. I like to call it a river when it's actually flowing pretty strongly, and a creek when it's not flowing very strongly. But I attended the last meeting about last night about what Kronos might be doing with the water supply, and I'm attending this meeting tonight. And I learned a lot as a citizen of this community from several different people that spoke there. I guess I'd like to second some of the concerns that I heard about at the meeting. I'd like to say that I'm concerned about the fact that I don't think that the plans that have been put in motion are thinking about possible long-range circumstances. We had one of the worst droughts in history last year. The water flow plans that were mentioned at the municipal plant dealt with flow rates that were taking into account the entire flow rate of the entire year, and we saw nothing that chronicled the flow rates during the lowest flow of those cycles. So I'd like to see more about that, and that concerned me. There was someone from the Illinois State Water Survey that came and spoke, and he basically said that Illinois had no law dealing with water management. That deeply concerned me as a citizen of the state, and I'd like to see that changed. I know the board is not bringing that up. But, and he also said that because of that, that both Kronos and the Bulldog Coal Company could, I mean, I'm not going to put words in his mouth, but it's basically that any company could do whatever it wanted to. I don't feel right about that as an American citizen, let alone an Illinois citizen or anything like that. I would like to see the board and everyone in our community treat most of our water resources as a vital resource. There was somebody that was on the environmental board who worked with the Jim Thompson administration, and he urged us all to think at that time of our sale of water as a possible sale or a similar sale as the island of Manhattan, that we could really be making a bad sale right now, because especially with Kronos, they're proposing this $1 million a year plan. I was thinking about that last night, and if it's not taking into account inflation or anything like that in the future, I don't know if that's a good deal. Inflationary dollars or anything like that. We don't have any idea of what the water resource is worth on the open market. So I'm not quite sure if that's a great deal. If we look at water as an actual resource that we should be dealing with. I addressed personally that I thought during high peak flows, there should be an idea, especially with Kronos and probably even the Bulldog plant, during peak flow rates of having major holding ponds. As a citizen, I would have no problem with them taking a lot of water during peak flow rates and storing it. I'm really concerned with them drawing the water during the low flow rates during the summer and the fall months, especially during drought times, because if they take half of the water from the creek or more, I'm really concerned that the creek's going to go dry, and I know the ecosystem can't sustain itself at that point. I've been hybridizing daylilies along the banks there. We have half an acre pond. We have 8 acres along the shore line there. And it was a really, really terrible year for a couple months last year. The drought was really bad. And that chart that was brought up with the peak rates, the average flow rates, the auxiliary flow rates that were going to be brought back in that would allow for Kronos to take the excess water and more flow to be brought back in. So basically, it was averaging out to be about the same rates as the 1990 rates or whatever. Seemed to make sense. I can't predict what's going to happen in the future. I know we had one of the worst droughts in our entire history.
You've used your time, sir.
Okay. I know we had one of the worst droughts in the entire history, and I'm really uncomfortable with long-range plans being made in such a short time.
Thank you. All right. Unless there are objections, the chair will entertain an omnibus motion for items 7A and B, a pair of entertainment licenses.
Communications first,
Oh,
Mr.
excuse
Chair.
me, communications. Do we have any communications?
Thank you. May I?
Sorry about that.
That's okay. May I?
Yes, please.
Thank you. Over the last few days, I've received, and I'm sure many of our other board members have received, dozens of emails, phone calls, letters. I want to apologize to those that I have not been able to get back to. I try to respond to every single letter and phone call. I've been away. I didn't get back till 4 o'clock this afternoon from Washington, D.C. on county business. So for those of you who have not yet received a response from me, I apologize. I'll try and get back to you as soon as possible. Thank you.
All right. Any further communications? Okay. Could we have an omnibus motion for items 7A and B, the 2 entertainment licenses?
Second.
Okay. Any comments on either one of them? All in favor, say aye.
Aye.
All opposed? Motion carried. All right. We have moved item 8D to the head of the 8 list. We need a recommendation to approve zoning ordinance text amendment to allow variances from municipal subdivision regulations for rural water district water treatment plant and related facilities. Now, we have a communication from the state's attorney calling for a revision of this. And we also are about to have some further modifications from the city of Urbana. So I would like to entertain a motion to defer until next month, June 6th.
So moved.
Second.
Any comments? All in favor, say aye.
Aye.
All opposed? Motion carried. Okay, we'll take this up on June the 6th. Now, well, excuse me, I'm reading the wrong piece of paper. That's not been known to happen. All right. Case 687 AM 11, recommendation to deny zoning map amendment to change the zoning district from CR Conservation Recreation to Ag 1 Agriculture to establish a restricted landing area pursuant to zoning case 688 S5. Motion to approve. That's 11, okay. Okay, motion to approve. Do I have one? Okay, motion to deny then. Okay, any commentary? This is the landing strip.
Right. What was, I'm new to all this. What was the big complaint about the conservation area around this?
Mr. Chair, I think we need the zoning administrator.
What?
I think we need the zoning administrator here. I think he stepped out, he may have to use the restroom, I don't know, but It would be more helpful, it would, because I
Maybe he's
think
gone to
Mr.
get
Harper's question could be answered, and I've got some questions myself too, that basically pertain to not so much the special use, but the zoning, the rezoning from the CR to Ag 1. So I just, while we're killing time, I'll go ahead and try to kill a little time here, if you don't mind, Mr. Chair.
Well,
Your
the
permission.
zoning administrator is calling the city of Urbana to tell him this other thing has been deferred.
Oh, yeah, I wish you would have
We
waited.
may have to wait a little longer than we want to. We can
Well-
just skip to the next item. How about that?
John, can you explain, to me, explain what's been going on?
Well,
Thank you, Deb. Get a hold of them.
okay. Well, basically, Stan, is we need to separate, and that's kind of what the point I was gonna make, the rezoning, the map amendment change from the special use, which is the RLA. So we've heard a lot of comments tonight about the RLA itself. Obviously, the special use has to take, basically second fiddle to the land map change, the rezoning change. So what we have is, in front of us is a rezoning from a CR district to an Ag 1, which basically in the ordinance is, there's not terribly too much difference from density usage from CR to Ag 1. Basically, as we go from density from CR to Ag 1, Ag 2, and the business zoning and also the industrial zoning, we go to more intensive uses, more dense uses, residential uses and such. So what we're doing here is we're trying to identify whether or not this is a good change from the CR district to the Ag 1 district, and how big a change. Now, we've got the recommendation from the ZBA saying, you know, we've looked at this and there's reasons, there are findings in here, why they think that shouldn't be changed. And I think probably the biggest reason is because there's so probably little CR district within the county that we're taking 14 more acres out of the CR district into Ag. Okay, well, I mean, from an Ag standpoint, you can farm CR the way you can Ag 1. I mean, from the farm standpoint. So what we're looking at is, okay, what other higher density uses can we get from this? Okay, and that's where the special use comes in, because it's not available, the RLA is not available in the Ag 1 district for LR or RLA, restricted RLA, yeah. Get my acronyms mixed up here, but that's why we have to change it, because the CR district won't allow this RLA in that district. So we have to say, okay, we need to change that density. So we go to the next Ag zoning district, which will give us that density. But it's not, there again, it's not automatic. In other words, you just can't change the zoning district and then you have the RLA. Stipulation is, then you must have a special use because you cannot get it in the CR. So, did that answer your question?
I think you did a good job. You can go back on the phone.
No, unless he wants to share his paycheck with me.
You still want to?
I have a question.
Okay.
How long have they been looking at this issue? Almost 2 years? Okay, and it's rare that we oppose what the ZBA recommends because of the finding of facts and because of all the information that they get that we don't see here. We can't talk about 2 years' worth of findings of fact, obviously. But what I can do is take the recommendations of the ZBA, who have tore this thing into pieces by now, obviously. And they came up with a 5-1 vote to deny this. And so just like I trust our committees and our committee structure, I trust the ZBA that they've done their duty and they've done their job. And so I will support their recommendation to deny this issue.
Any further comment? Okay.
Well, if this guy would put 14 other acres into conservation, he has a fair amount of forested land, wouldn't a trade be possible?
Well, that's up to the board.
Well, he hasn't mentioned that. Would he be willing to do that?
That's right. All you have before you is the record of the public hearing.
Okay. John, going back to what Mr. Kurtz was asking about, this case it's almost going on 2 years now since the initial public hearing. Well, I'm just curious, just for information, was there, obviously there was a lot of information that went into this, but was there any problems that occurred that would push this along? Was it the scheduling? Was it the order of cases that maybe had higher level or anything? I'm just curious. It's almost 2 years, so.
In fact, the main problem was a confusion in the beginning. The petitioner's original application requested an RLA and a heliport RLA. Our zoning ordinance has both. It doesn't define, you have to look in the definitions to define what it is. And I'm glad you asked this question, John, because this was a staff error in the beginning. We advertised it as a heliport RLA. And everybody saw that there was an RLA and there was some amount of helicopter use proposed. And finally, in November of 2011, I realized, okay, there's been confusion here. The petitioner originally wanted both an RLA and a heliport RLA. You've been around long enough, you know that's two principal uses. Two principal uses have to be on two different lots, which raises a whole host of questions. And so I had to tell the petitioner, we've made a staff error. We only advertised this as a heliport RLA. What would you like? And actually what would have worked was an RLA with some limited helicopter use. So I had to ask IDOT, IDOT, would you allow an RLA with limited helicopter use and not require a heliport? I wrote about a 5-page letter to IDOT, and we waited, and we waited, and we waited. And finally, in April or May of 2012, we got a reply, very well written, and yes, in fact, they would allow limited helicopter use without a heliport RLA. So at that point, the ball was in the petitioner's court. Now knowing what the county would require for what he originally requested and what IDOT would allow, and subsequently what the county would allow, he had to decide what he wanted. And in fact, that took about 4 months. And so a lot of this time was not for ZBA deliberations, but it was to correct a staff error, and the petitioner absolutely deserved that error corrected. And then for the petitioner to regroup, and what he ultimately requested of the ZBA was simply an RLA with limited helicopter use. And so I don't want to misrepresent it. There was a lot of testimony in the cases. The neighbors were highly motivated, and we had lots of data at every meeting. The petitioner was highly motivated. And so eventually, the ZBA was able to make the recommendation they've made.
Thank you, John.
Any further comments? Oh, yeah.
Yes, I have one question for John. Did the state define what limited use is?
No, they didn't.
I thought
The
so.
ZBA did, however, so we know
Okay.
what the ZBA limit for both helicopter and fixed-wing aircraft use. The ZBA put a limit on both.
Okay, and then as to Ms. Bergson's question, did the ZBA ever ask that question?
No, I think the ZBA felt comfortable with the very low restrictions that they were considering.
Okay, let me take that then to the next step. Had the ZBA asked that question, is it a probable possibility?
Converting other acres.
Yes.
Yeah, of converting other acres.
Oh, I thought you were talking about the amount of use.
No, no.
Patsy's asking about converting other
No,
acres.
what Astra talked about.
Oh. I really can't say. All I know is the petitioner, I believe, moved the RLA as far away from the other development as he could, given his original legal description. And the ZBA doesn't really speculate much in their public hearings. They listen to what you're proposing, and then they pass judgment on it.
But they do ask questions, and so
Yes.
and it's clear to me that that question then wasn't asked. Okay.
Getting back to what's being asked, the map amendment change from CR to Ag 1, and Astrid, you bring up an excellent point. I appreciate that, being able to maybe switch 14 from 14 if that's possible. I think, and we can't help it here, that we're going into we're swerving back and forth into the special use, into the rezoning and such. And I think that's one of the things that when it comes to the special use, since I threw in the special use, make the point of, that's where, I mean, the case can be made for the LRA or not. And that's where if the RLA can be put into place, that's where the restrictions can be put in by the special use permit by the ZBA. In other words, so many flights per day or week, or how many helicopter flights per week, times of operation, the amount of planes or aircraft that can be around one time, or none whatsoever. It can either be as conservative or as liberal as you want to be, and that's the point here with this, and that's why I'm a little lost why the rezoning exactly. I mean, I read through their findings and everything, and they went through all the different bells and whistles, all the parameters they had to meet, Sinclair, LaSalle, and they had to go through the LRMA and I get that mixed up, I'm sorry, Land Resource Management Plan. I'll just say it, I'm bad with acronyms, Land Resource Management Plan, stuff like that. But I really think that a lot of it was drawn more towards the special use than it was the actual rezoning. And I have a real hard problem with, I believe in people's private property rights. And I think from this standpoint, we're just changing from a rezoning from a CR to an agricultural 1 district when it's all surrounded by ag basically, except along where the ditch is basically. I mean, there's ag frontage along with that. But I'm concerned that this kind of got skewered with the special use. And I kind of have a problem, and I understand why the ZBA did it. I guess I'm not trying to step on your feet to put it in layman's terms with this. I just wish it was more clarity of why they thought that the rezoning wasn't worthy. And with that, I'll go back to what Astrid said. I think that's an excellent point.
John, could I explain? Sure. I'm glad you raised that question because I believe in your days on the ZBA, the map amendment was reviewed as a map amendment and the special use was reviewed as a special use. And they won, the map amendment might be reasonable without the special use. You may be pleased or upset to find that the LRMP in all those policies refers to discretionary development approvals, and I believe you have to read discretionary development approval in this context as a request for a special use permit pursuant to a map amendment. It's not just a map amendment, it's a map amendment and a special use permit to go along with it, and both items get reviewed under the policies. I don't know that that was intended in the LRMP. The discretionary development is clearly defined in the appendix as a development wherein the county has to make a decision. And so it doesn't distinguish between a special use permit, a map amendment, or both in related cases. And so I advised the committee or the ZBA that if they looked at it as just a map amendment, they were missing half the picture as a discretionary review development. Both things were related. And that's why it's different than, literally different than past practice.
If I could respond.
What?
If I could respond. Can I respond?
Sure,
Oh,
go right ahead.
okay, thanks. No, I understand that.
Okay.
I understand that, but I guess I wasn't clear enough to say, I think the emphasis was more on, like you said, the planned use development, because the special use does go along with that, but it is something separate from the standpoint of this board approves of rezoning of it, whereas we do not have any approval or say over the special uses or variances that come before the ZBA. So I think my point was, yeah, I understand that, but we don't see the special use side of it here. I mean, we can see the rezoning side of it, and we understand why the ZBA did what they did, but my point is I think from our standpoint, we have to see that, and that's why I mentioned, when I was explaining it, I see that they did go through the land resource management plan and all that. I understand that, but I appreciate your comments. Thank you. But I was just making the point that we're seeing that and the rezoning of it, and the rezoning is what I was kind of keying on with that.
Okay. I've had a chance to read Mr. Singleton's screed, which you've got here, and somewhere in there, and I can't tell you where, there's a statement of how many flights the helicopter is expected to take a year and how many flights the fixed-wing plane is supposed to take in a year. And I think it's 5 flights by that helicopter into this thing. Anyway, there's a statement in there somewhere that does limit it, but it's a pledge. It isn't written into it. Okay, now, you want to talk? Oh, that's fine. Thank you.
I have a question, John. I'd like to take a little different tack. There was a lot of opposition. Can you tell me about how many people, was there a petition given to in the fact? I thought there was one, wasn't there?
Yeah, and that was attached to the memo I handed out tonight because
I didn't get a chance to see that one.
there's a memo on this case.
Oh, here it is, okay.
And the reason I handed it out tonight was I realized it wasn't on the webpage, the ZBA webpage. It
here it
will
is.
be
I
as
see it
of
now.
tomorrow.
5 pages of opposition?
Yeah, 33 original, and one person took their name off this list, so 32
Okay.
individuals.
There's like 30 some odd names here.
Yeah.
Okay, thank you very much. That's what I wanted to know.
Okay, are we ready to vote on this? Okay, a yes vote means you're denying this. All in favor, say aye.
Aye.
All opposed, say nay. Nay. The ayes have it.
Wait, which way was which?
What?
Which way was which?
I said a yes vote denies this request for denial.
Then I changed to no.
Okay, now there were 2 of you that said no? I said no, yes. Right. Okay, so all right.
Motion
The ayes
passes.
have it, the permit is denied.
Correct.
Anybody got a comment on that now? All right.
Well, but it does go forward to the full board.
Yes. Yeah, we send it to the full board with, as written, recommending denial, which means that we have to go through all of this again. Okay. We're down to item 8B.
Mr. Chair,
What?
may I ask a question of clarification of our Director of Planning and Zoning? First, I want permission. May I ask a question of clarification?
Sure.
Okay, this is just a question of clarification. Since this has already been through the ZBA, would there have been an option for us to remand it back to the ZBA for them to consider what Ms. Brooks had brought up?
You can always remand if you think it needs to be reconsidered.
All right, thank you.
And you can do it at the meeting of the full board.
That's why I asked my question of clarification.
Okay. Okay, item 8B, case 741-AM-13. Recommendation to approve zoning map amendment to change the zoning district from 1-1 light industry to B-4 general business to establish a firearms sale store and indoor shooting range.
Second,
Okay, any discussion?
yes.
Yes, sir.
I just want to make my position clear. I'm opposed to guns, and I'm not opposed to guns. I'm opposed to certain areas of legislation that we have that we need to control our guns, we need to control universal background checks, which hasn't happened. The state of Illinois, and the Supreme Court, in its wisdom, has stated that we're going to have concealed carry, and the state legislature is now working on legislation towards that, and I had discussed some of my suggestions with Senator Raoul, who was writing the bill as we speak. I asked him to do certain things about concealed carry, like it should be age 21, that if someone is caught drunk at a .08, the DUI laws kick in just as the same. No guns on campus, and a number of other suggestions that I made, hopefully encompassed in that bill. But it's inevitable. We're going to be the last state in the United States to have concealed carry, and it's going to happen. I will support this resolution because I think if we're going to have concealed carry, we're going to need to have a training program. And the gentleman, where's the gentleman who is going to put this in? Yeah, would you please, may I ask a question of this gentleman?
Of course.
Thank you. What's that? Suspend the rules. Can we have a motion to suspend the rules, please?
Second. Okay, all in favor of suspending the rules?
Aye, thank you.
All opposed, say no. Go ahead.
Thank you. What is your name, sir?
My name is Marcus Harris.
Hi, Marcus.
Hi.
Nice to meet you.
Nice to meet you, too.
I feel it's important that we have some, I think the closest shooting range is Bloomington.
Darnell's in Bloomington. There is the Bullet Trap, which is down in Macon, which is just outside of Decatur. And then the next one would be Capitol in Springfield. So every one of the closest ranges is about an hour.
All right, so it's going to be an indoor range.
It will be an indoor range only.
Okay, so we're not going to see any bullets flying around the ag district out there. Good. And how many lanes do you have?
It will be a 10-lane range rated for both rifle and handgun, 75 feet in length. The range will be provided, will be provided by Action Targets, which is a nationally known range company. They provide for the CIA, all armed forces, many police, and so on. So they'll be the ones that will be providing the bullet trap, the ballistic shielding for the ceiling, the ballistic partitions, the targeting systems, and all of those things, so.
All right, and nothing more than rifles and handguns?
Correct.
Okay. You'll be selling guns?
Yes.
Check, everyone will have a background check?
Yes. We have 2 FFLs. One is DNR firearms, which DNR, as you saw in the packet, Dean Hazen is a police officer with the city of Urbana, has been in service, I don't know how many years, I think he's 14 years now going on. We also have Tim Murray, who is of the Morgan Group. Tim is actually a firefighter on Champaign's fire department, also he's a SWAT medic, and he would be the other FFL. So we take our responsibility to do all of the things that the government regulates to make sure that it is safe. And that's one of the reasons for this venture. I got into it was because I was the same as you. I felt there needed to be a facility with classrooms, with good teaching. I think it's kind of silly that an 18-year-old can get a FOID card, go buy a firearm, and they are considered trained. We don't do that with 16-year-olds that want to drive a car. I don't think we should do that. So one of the focuses is going to be safety above all else things. And so we will have 3 classrooms in the facility, and we will teach the NRA basic pistol course. We will teach right to be a victim courses for females, which is not actually anything to do with handguns. It's actually personal protection. We will also be teaching gunshot wound classes, so anybody who would have a range accident or a hunting accident. We plan on teaching the hunter safety courses, which is required for you to get a hunting license in the state of Illinois, which it's hard to find a place to teach that. So we take education as probably the most important thing here, along with the providing a place for people to safely shoot. That was the other reason I got into this, was because I realized that the only place you can go shoot right now is either one of the places that's an hour away, or if you know someone that has land and so on, and that's inherently dangerous. It would be better to create a facility that is adequately built. And to let the committee know, this facility will cost somewhere in the neighborhood of around $800,000 by the time we get done to put in the correct air handling systems, put in the ballistic shielding, and so it's not a small undertaking by any means.
How many employees will you have?
We'll start out we will end up with about 12 to 13 employees. That will encompass, we will have, of course, check-in, we'll have range safety officers, we will have salespeople at point of sale for firearms, and we'll have, on average, the staff will consist of about 4 to 5, depending on the time of the day and depending on the weekend and so on, because weekend times are usually higher on ranges, so on and so forth, so.
Well, one of my suggestions to Senator Raoul was that anyone new who gets FOID card has to take training.
Yeah.
And I think having you here locally will be very helpful in that area, and so I will support this resolution. Thank you very much.
Okay.
Sorry, got turned on. I'd just like to thank you and applaud you for bringing this into the county. I've thought personally for a long time that it'd be nice to have something like this in the county. And on cost alone, you mentioned the regulations. I know those have got to be piles of paper basically to search through and make sure you meet all of them. I personally believe that we should have the right to carry it. And it's about time we get it in this state. So I guess to Mr. Kurtz, the idea
Okay,
of having
guys,
having a
cool it.
gun-free zone at the schools to me is stupid because that's where the mass shootings we've had have occurred. But I do applaud you for doing this. I know training and safety,
Yeah.
and I thank you for including that as a big part of your business, and I hope you make a go of it.
Thank you.
And
I was going to mention too, I forgot
Thanks.
the gentleman's name, is it Alan? Also, you had mentioned that keeping the university, especially keeping guns off the university, we will also have a gun lockup for students who come to the university so that they won't be storing their firearms on the campus. They can store their firearms for a fee on our facility, so if they want to come. So lots of people coming down from Chicago suburbs, especially students, and also hunters that are local to the area and gun enthusiasts. They come to the university, they're not allowed to have guns on campus, either in residence halls or otherwise. We want to provide a safe place for them to store their firearms and use their firearms, because again, it is about shooting sports also, and so.
Well,
Patsy?
may I? Oh, I'm sorry. Patsy, she has.
Yes, I have several questions. You've spoken quite eloquently on all the steps and rules and regulations for safety inside the building. I'd like to hear what your plans are to make certain that the exterior of the building is equally as safe for people who are not coming there to shoot, but will be in the area because there are other businesses and entities out there.
Are you addressing security from outside sources coming into, say, steal firearms? Or are you talking about from the ballistic shielding and envelope that the building provides? Which one would you like addressed?
Well, actually, I'm more focused on rules of the road that you are going to put in place for how people enter your facility with their guns, the handling of things of that nature. The other two are equally important, but I think you've covered some of that.
Okay.
I'm more interested in that latter point.
Well, of course, security is a huge issue to us, again, with the safety of transportation. Currently, the state laws, because we are not a concealed carry state law states that if I want to carry my firearm to a facility to go shoot, so for example, I want to go down to Macon, I need to case that firearm. It needs to be unloaded, in other words, magazine not in, and ideally, I'm not sure what the state says on this one, but most sport shooters will not have the magazines loaded with ammo. They will have an ammo in a separate location. I personally lock my ammo up separately from my firearms in order to transport. We will of course follow all of those rules that they put forth. No firearms will be uncased in the facility until you are on range. All firearms are to be pointed downrange at all time. We will have security cameras and range safety officers to view and take care of. Any infringements of those will be reprimands first, and then eventually a person can be not allowed on the facility. Again, we take safety because, again, liability-wise, insurance-wise, my insurance company will kill me. I mean, just kill me if I don't do the things that I need to do to be safe. And the ATF puts down regulations for me, the EPA for safety, local law enforcement, and so on. And we've talked to the local law enforcement, the local fire protection. We've put into place security plans also for our facility, which will include our range has a electronic lock so that no one can walk from the sale area into the range accidentally. There's a double system of doors for air, so that, again, air quality is not mixed between our retail shop and so on, so, yeah. Did that answer? I don't know if that answered or not, I want to look. Okay.
Okay.
Just one more point, Aaron. Okay, I see, we're on different sides of the aisle on this one, but that's okay, because we're probably going to come down on the same side on the resolution. But the one thing I've learned, and I've seen it, I've been here 34 years, is nothing good happens on campus after midnight. And if you talk to any of the local police forces, whether it be the U of I, Champaign, there's a lot of stuff going on, fisticuffs and knifing after midnight when they come out of those bars. And I don't want to see now that they'll have, 100 or 150 sidearms walking around at 2 a.m. when these kids are inebriated. So that's just my feeling on that. But yes, absolutely. So that's my only my major concern when it comes to the kids on campus. But I think what you're doing, and you're putting in quite an investment as a business professional, and I want to thank you for delineating so eloquently what you're going to do with this shooting range. Thank you.
Well, thank you.
Okay, Patsy.
This statement, I mean, I don't have questions for you, so I was waiting to make sure everybody had finished questioning you. I'm not going to vote yes on this. It has nothing to do with your business at all. It has totally to do with the way the zoning's being handled and being moved from ag to business and the way our zoning is set up. I mean,
It's not ag, it's industrial.
I mean, like, I'm sorry, I didn't mean ag, because when I started researching this and looked at what Urbana has said in their ordinance, and we are not in sync with them in the way they're handling this kind of business and within their area of zoning. And I have mentioned this to Mr. Hall, and this is just sort of patchwork, and I would have much rather seen what is allowed within the zoning category be changed rather than the whole zoning category be changed
So
to accommodate this.
So similar to what Urbana requested?
Correct.
Okay, okay.
And plus what Urbana also considered in what was written in that ordinance. We're not considering that. So I want it very clear to you,
Okay.
when I vote no, it
Okay.
has nothing to do with your business. It has to do with how the zoning has to be changed to accommodate your business.
Do you know what I'm sure you're familiar with what the city of Urbana set forth then, that they would allow a range in an I-1 or a B4, so if this were actually in city of Urbana,
Right.
we wouldn't actually be having this meeting, it
I
would be
know it.
by right.
I know it.
Okay, I just
know.
wasn't sure, I wanted to make sure, because
Oh, no,
that was a
no.
long process on my
No,
part also.
No, I read it.
So,
I found it
okay.
today, and I read it, and
Okay.
and after I read it, I contacted Mr. Hall
Okay.
and expressed my concerns that it's more patch quilting our own zoning ordinance that is bothering me.
Okay,
Okay, it's clear to you, the reason?
yes,
All
yes,
right.
that's,
Oh, okay.
I have a question, Ms. Petrie. Are you referring to Urbana's comp plan?
No,
What's going on out there, or you're
No,
concerned
no.
about with?
no, this came up last August. Robert Myers wrote it. You can find it. What they did, because I can't ask you that question. Were you the entity that approached
yes,
them?
I can.
Okay,
I-
that
do
was
you want
the
me
trigger mechanism.
To address, can I address
No,
that
that's
point?
up to
Down
the
in
chair.
Urbana. Okay. Any further comments?
No, I just wanted to make it clear why my vote's going to be
Okay.
the way it is.
All in, yes, sir.
Thank you, Mr. Chairman. I just wanted to relate to you, other than the Sangamon Valley Public Water District, I've had more calls on this gun range than any other item that's come before us, and from all over the county, not just from my district. In fact, a lot of them might have been from Al's district, now I understand why, but I didn't have one bad call, one negative call. They were all for it, which is kind of unusual. Thank you.
Okay. All right. Are we all done now?
We're passing the box.
Okay, all in favor, say aye. Aye. All opposed, say no.
No.
Motion carried.
Thank you for your time.
Yep. Wait a minute, where am I here? Okay. Case 734-AT-12- final recommendation to approve zoning ordinance text amendment to change requirements for a contractor facility. You have anything you want to say about this?
So moved.
Any discussion? Really? Come on, guys.
Been there, done that.
This can't happen. All in favor, say aye.
Aye.
Okay. All opposed? Motion carried. All right. E, recommendation to approve compliance commitment agreement with the Illinois Environmental Protection Agency, IEPA, for the National Pollution Discharge Elimination System, NPDS, Municipal Separate Storm Sewer System, MS4, Stormwater Drainage Permit.
Second.
Any discussion? Hearing none, all in favor, say aye. All opposed? Motion carried. Okay, now we come down to the addendum. Proposed resolution opposing water withdrawal from the Salt Fork of the Vermilion River for coal mine site use in Vermilion County. Any discussion? You so move? We got a motion in a section? You moved, who seconded?
I didn't hear, what was the motion? Okay, I'm sorry, I didn't hear.
Okay. You got a second?
Second.
Okay, go ahead.
Mr. Hall, where did this resolution come from? Who brought it forward?
It's my understanding that Mr. Harper had forwarded it to the committee.
Okay. And has any of this information been vetted through zoning office?
The only thing I can vet is that we do not have a comprehensive plan. We have a land resource management plan.
Right.
And frankly, when I read this, in some areas, it seemed as if it was suggesting the coal mine is proposed in Champaign County, and it's clear that it is not at this time.
I can't support, I mean, it's poorly written, it hasn't been vetted, and besides that, it was delivered yesterday morning. I haven't had a good chance to go through and look at this thing. Yes, it was, Patsy. It was brought in yesterday morning, the Planning and Zoning Office got it yesterday morning.
I may have, let me clarify that, Mr. Schrader. We had it when the item was added to the agenda. It just didn't get attached at that time.
Okay, that's my clarification, and because that's what you had told me over the phone. Okay, but it's my fault that I have not been able to see it because my internet service provider has been down for a day. So I have just gotten emails tonight that I have not seen before. And beside that, there again, I mean, I look as a second whereas where I've read in the paper, I've watched this process at Homer through the paper, and I've not gone through all the facts to go through to make a decision on this, proper decision, but the only thing I've seen from withdrawal from the Salt Fork would have been a 500,000 gallon, 530,000 gallons, and now I'm seeing 750,000 to 1 million gallons. So I don't know how accurate this fact is because it hasn't been vetted properly. I cannot support this, period. And beside that, this also mentioned Vermilion County, which we have no jurisdiction over. I know it says use, coal mine use in Vermilion and Champaign County, but there again, a lot of this is vented toward Vermilion County. And also the way it's worded, there's no way we can support this. This is flawed, the way it's written.
I think there are some errors in this resolution. I support the idea of this resolution, but I think we should defer this. I think we should move to defer this until we can correct the resolution and make it certainly more clear than it is, and then we can discuss it and have a chance to review some of the information like the 750,000 gallons to 1 million gallons, where it, in this first paragraph where it states, potable water, in order to place underground mine operations within the confines of Vermilion and Champaign counties, which is not actually true. It's only going to be in Vermilion County at this point, and that's all the permit has. So I would like to defer this and have it rewritten and then brought back to
Is
us
that a
next
motion?
month. That's my motion.
Second.
Okay, it's been moved and seconded to defer this till
There was
when?
already a motion on the floor.
Yeah, there's a motion on the floor.
Motion to defer, take precedence.
But he's proposing a new.
The motion deferred takes precedence.
No, he's not adding anything to this. He's just asking that things be clarified
Right.
and things be exactly what I was saying.
It
That
has been moved and
language
seconded to do
correct.
this, and you are now moving and seconding to defer it. I
Correct.
see
That's
no
correct.
objection to that.
Correct.
Is there any discussion on the motion to defer?
Yes. I think,
Give it a microphone.
Go ahead.
I think we could, it's close enough, I think we could ask that a corrected version, if we like the idea, we could have a corrected version presented at the board meeting.
Oh, that's a suggestion, in which case you would defeat the motion to defer. That's an
That's
argument.
right.
Okay, are there any further comments? Patsy?
I wonder if the motion to defer could be withdrawn to allow discussion to put forth concerns so that when it is either deferred or asked to be rewritten, the concerns get laid out, so when all of that happens, we can capture those concerns.
Are you gentlemen?
We
willing to
cannot
withdraw?
discuss that on a motion of deferment.
That's
Are
correct.
you guys willing to withdraw your motion?
So that's,
Oh, he wants to.
that's a request.
I understand that, and I think it's something that it's pretty obvious, and John mentioned some, I mentioned some of the things that need to be looked over. Just in general, the document needs to have a vetting. I appreciate you bringing that up, but I don't think there's anything else that could be brought up. And I'm back to speaking to the motion on the table or on the floor right now. I don't understand which is deferment. I'm not sure what the rush is with this. And if there is a rush for this, where it couldn't be deferred for a month. And we didn't put a time on it.
No,
We're
but I'd like
deferred,
to
but I think a
defer. I
month
did
would
say
be.
for a month.
For a month, okay.
Yeah, to the next
I think it
Okay,
would be instructive if we just did it for a month, and that way it could be
You accept
vetted and we
that-
could find
that-
those.
that change
Because like I
of-
said,
No,
I
that's
haven't,
part of the motion. I said next month.
right.
Okay, well, that's the
It's
change.
still
to
part of
the motion
deferment.
To defer, yes.
It's still part of the
You're
deferment.
deferring it for 1 month. Both
That's
of you
correct.
now? Okay, fine.
Very good.
Yes, sir.
To clarify with John, yes, that resolution was mailed to me. As some of you may not know, I've been down to some of the Homer meetings, and I've gotten to know some of the people and the farmers that have legitimate concerns. Yes, I'm a ag guy, and I hate to see ag, but I do agree that there's some clarification, and I support your deferment until we get it clarified.
Ralph, may I respond? I think what we're going to do, we can send all our suggestions, whatever, to John. We could set up the new resolution, have it sent out to the board in plenty of time for comments if necessary, and then bring it in this deferment and bring it to the next committee meeting with all the clarification suggestions on it.
Any further discussion on the motion to defer? Okay, Patsy.
I would like to ask support to suspend the rules for one question from somebody knowledgeable in the audience to ask if a delay of a month has any negative aspect in relationship to what they think will be happening in Homer.
Well, we need a motion to suspend the rules. You need a motion to suspend the
know.
rules to do that. You're moving to suspend the rules?
I need to,
All in favor, say aye.
aye.
All opposed, say aye. No, 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 no.
Okay.
Okay, let's take a count. For or against? What?
Once you raise hands, all for suspending the rules. All for suspending.
You're for the suspension. Are you for it? You're for it. You for it? You for it? You for it? That's 3-3, isn't it?
You cast the deciding vote.
What a pity.
That's what you get the big bucks for, Ralph.
Okay, yes, that's right. Well, I'm in favor of letting people talk, as you may well know. I'm for it. Go ahead.
So,
Pick out, how you gonna pick out somebody out of the crowd? You gonna pick out one side or the other?
no, just asking the question if anybody knows.
No, how can you ask a question of anybody and just pick out somebody out of the crowd?
Why not?
Because we don't know who they are, we don't know what side they're on.
Let her do her job.
I would like to ask Tracy if she could please give us some timeline information. That's all. Would be helpful in relationship to the deferment.
Thank you. I think the relevant dates are that the DNR permit application was submitted last June. So that was June of 2012. And that is being acted on by Illinois Department of Natural Resources, Office of Mines and Minerals. It is in process right now. The other relevant piece is that there is not, to our knowledge, an official proposal from Sunrise Coal to the sanitary district, but there have been discussions. Sunrise Coal is interested in UCSD contractually being obligated to have a certain amount of their effluent be in the Salt Fork River for their withdrawal downstream. I'm not aware of any timeline restrictions, in either direction that UCSD is under for making a decision. I think that proposal could come any day, and they could make that decision at any point. They have honored a public meeting last night. They are accepting comments, but I don't know of any restrictions as far as timeline for when that could be granted. So I do think, this mining company has been leasing mineral rights for 2.5 years now. They have secured a certain amount of mineral rights. They are moving forward, and I do think this is very timely considering that there are, there's been pressure on the Salt Fork for their water withdrawal and water needs.
Okay. Any further discussion on the motion to defer?
Roll call.
I think so. Roll call vote.
Kurtz. Yes. Petrie.
Yes.
Schrader.
Yes.
Esri.
Yes.
Bergson.
No.
Harper. Langenheim.
No. The ayes have it, so it's deferred. All right. I think till next month. Okay, we're down to item 9. They're provided for information only. Item 9A, CU Area Medicine Take Back Program. Anybody have any comments on that? Yeah.
Hi, I brought this before you as an information item because on next Friday, you're going to be exposed to a media blitz about this program. I wanted you to be aware of it in advance. So I'm here to answer any questions. It's a program that is long in coming, and it will serve to protect water resources and public safety.
Okay.
Susan, thank you for bringing this to our attention. I did talk with the person behind the program, And when I spoke with her, one of the concerns I have in this Media Blitz and educational week is to cover how illicit drugs, syringes, needles, and thermometers can be handled, since these are not going to be part of the accepted items, and I can envision people just doing everything that you don't want them to do with them. So I
Good
hope that
point.
will be
Yeah.
included.
Good
Thanks.
point.
Okay. Item 9B, notice from the Illinois Department of Natural Resources regarding the Bigger Waters Flood Insurance Program Act of 2012. Any comments? Okay. Monthly reports. Do we have any reports? Do we have any other business?
Mr. Langenheim,
Yes, sir.
I hate to prolong this situation, the situation you put us in, Mr. Langenheim, but I must. Since Cronus keeps being brought up in this committee, which is not in Champaign County, which is in Douglas County, which is a private business, which has nothing to do with this county except they want to do the right thing and buy effluent water. And all the voices I've been hearing when Anderson's wanted an ethanol plant said, why don't you buy the effluent water and don't take our drinking water? And now the effluent water, the right thing to do in Cronus, we can't do that. The dirty little secret is this is a fact. If Cronus wants water, they can go to American Water and say, we'd like to buy some water from you. And American Water, due to the state statute, would say, yeah, we'll sell it to you. That's a dirty little secret. So it seems like those who want to do things right are the ones who are smeared and thrown up against the wall to see if it sticks. And I'm not sure, Mr. Chair, if we shouldn't do something in the near future, maybe the next meeting, and talk about Cronus, since it's such a big issue, to clear the air on this. Because I'm getting sick and tired of this misinformation that's coming about this water issue. So it's up to the chair's purpose. I'd be happy to put some information together at the next ELUC meeting, but I wanted to clear air on that, and I appreciate all of you listening. Thank you.
We're not about to stop you from shooting off on anything.
If I want to shoot myself, I'd be happy to shoot myself.
I am a lenient chairman in that regard. Yes, ma'am. You can shoot too.
I can shoot. Thank you very much. I did attend the public hearing last night at the sanitary district, and I was very impressed by the turnout. There were probably 90 people there, bringing forth many different aspects, and I do think it's worthy for us as a county to be thinking about this. It depends on where the water comes from, and if both companies want water from the Salt Fork, then it becomes a very serious issue. And it may be in another county, but we still have to think about things regionally, and that's why I think it is important for us. We thought regionally when it came to the PCBs on the Clinton landfill, because it affects our water. So we've got to be thinking. I can see this is going to be a tough meeting. Yeah, I know. I can see it's going to be a tough meeting. Yeah, we'll go. We'll go. Okay.
All right. No, we have a few. Is there any other business?
Well, don't we have to move to accept this report on file?
Okay, move to accept it and put it on file. Is there a motion?
So moved.
All right, all in favor, say aye. Aye. Opposed? Okay. Now, is there any other business? The chair has a report. I apologize for my ineptitude tonight. I don't know what's got into me. Now, designation of items to be placed on the consent agenda.
C&E.
Hmm?
C&E. C&E.
C&E. The entertainment licenses.
Those stop here.
Yeah, okay. C&E, it is. Do I hear a motion to adjourn? Do I hear a second? Is anybody opposed to adjourning? We're adjourned.